In Canada, the Canadian Food Inspection Agency, the CFIA, is one of the most powerful federal agencies in the country. Tasked with protecting public health, food safety, and animal welfare, it wields sweeping authority to seize animals, order mass culls, and dictate the terms of agriculture and trade. But in recent years, that authority has faced growing scrutiny. From the skies where draft horses are flown across oceans to their deaths, to a quiet farm in British Columbia where hundreds of ostriches face extermination, a troubling pattern is emerging. When the CFIA is challenged, the courts almost always side with the agency, even when animal lives hang in the balance. And by the time appeals are heard, it may already be too late. The story begins in 2018, when the Canadian Horse Defense Coalition took the CFIA to court. The coalition accused the agency of violating its own animal welfare rules by allowing large draft horses to be crammed into wooden crates for long-haul flights to Japan, where they would be slaughtered for meat. Many of the animals were transported without proper separation, food, or water, some even exceeding the legal 28-hour transport limit. The case seemed straightforward. The health of animals regulations are clear about how animals must be handled in transit. But in 2020, the federal court dismissed the lawsuit. The judge ruled that the CFIA had broad discretion in how it interpreted and enforced those regulations, and that it had no legal duty to apply them the way the coalition argued. The decision was appealed, and the appeal failed. Once again, the courts sided with the CFIA, finding its decisions reasonable and within its authority. In 2025, a new complaint by Animal Justice detailed further evidence of violations, but the CFIA faced no charges. It investigated itself, and the shipments continued. For the horses, there was no second chance. They kept flying, and they kept dying. Nowhere is the power of the CFIA more visible than in Edgewood, British Columbia, home to Universal Ostrich Farms. In late 2024, a handful of birds tested positive for highly pathogenic avian influenza. The CFIA's response was swift and absolute. Every ostrich on the farm, more than 400 in total, was to be destroyed. It didn't matter that the vast majority were healthy. It didn't matter that months had passed without new cases. Exposure, the agency argued, was reason enough for a total cull. The farm fought back. They filed for judicial review, presenting new scientific evidence that many birds carried antibodies and posed no ongoing risk. They pleaded for a targeted approach, or at least the chance to study the animals before killing them. But in May 2025, the federal court ruled in the CFIA's favor. The decision, the judge said, was reasonable and lawful under the Health of Animals Act. The court refused to consider new evidence that emerged after the CFIA's original order, ruling that the agency's decision must be judged based on what it knew at the time. The farm appealed. In August 2025, the Federal Court of Appeal once again upheld the CFIA's decision, and again refused to admit additional evidence. Only a last-minute intervention by the Supreme Court of Canada, a temporary stay granted on September 24, 2025, has kept the birds alive. For now, the ostriches remain under CFIA custody, fed, watered, and monitored, but that reprieve is fragile. If the Supreme Court declines to hear the appeal, or if the stay is lifted, the cull could happen within days, long before the case is ever fully argued. What links the horses in the sky to the ostriches in British Columbia is more than just the CFIA. It's the courts themselves, and a consistent pattern of judicial deference. Time and again, Canadian courts have upheld CFIA decisions, citing the agency's scientific expertise, its statutory mandate, and its discretion under the law. Judges repeatedly conclude that CFIA orders are reasonable, even when they result in suffering, death, or disputed interpretations of the law. In the horse export case, the courts ruled that the CFIA wasn't obligated to enforce its own regulations the way advocates believed. In the ostrich case, they refused to weigh new evidence that might have spared hundreds of lives. And across other cases, from livestock transport to farm inspections, the trend continues. Courts defer. CFIA prevails. Animals pay the price. The CFIA was created to protect animals and public health. But when oversight becomes unchecked authority, and when the courts refuse to challenge that authority, accountability fades. The horses shipped overseas. The ostriches waiting under lock and key. Different stories, united by one question. When government agencies go too far, who will stop them? Because if justice comes too late, it isn't justice at all.